You talk about the ROC Constitution. In 1947, or before 1947, due to the Civil War, the legal knowledge and system was not really mature enough. That's why there are still some blind spots in our Constitution, but it's really time-consuming to amend the Constitution. So we came up with some additional provisions to the Constitution over these years. You talk about rights. There are abstract rights and concrete, tangible rights. In our Constitution, in Article 20, people's rights shall not be infringed upon if such rights does not infringe upon other people's rights or harm social order. For example, the sunshine right and personal dignity are examples of this kind. And according to the Constitution, no restrictions shall be imposed upon the protected basic rights of the citizens unless, say, public safety is at stake or national security is at stake. As for the right to housing, does that mean it is not included or written down in the Constitution? It is not a right that ought to be recognized? I don't think so. As for the rights enshrined in the two covenants, as we have tried to incorporate these two covenants in domestic laws, and we listened to our colleague telling us how many decisions that have cited the covenants. So progress has been made, and it takes time for the domestic laws to be fully aligned with the two covenants. At the end of the day, we still have to respect the judges.
Please. 我们委员提到，
As you mentioned, whether people in Taiwan can directly invoke the two covenants and to assert their rights recognized in the two covenants. Well, in fact, based on our Implementation Act, they can do that. But our courts and our administrative agencies may not have enough understanding of the two covenants. Maybe on the other day of our review meeting, we'll be talking about the implementation of the two covenants. So the correct interpretation of the Implementation Act is very important, because we can invoke the two covenants in our courts. But the judges tend to combine the provisions in the two covenants and domestic laws when giving a decision. But in fact, they can directly invoke the provisions in the two covenants. But again, I think it takes time. In a very short future, we can do that.
Could I just add a short comment before giving the floor to my colleagues? The Committee on Economic, Social and Cultural Rights, way back in, I believe, 1990, adopted a General Comment number 3, on the responsibilities and obligations that state parties have, and to read the covenant in such a way that there are only discretionary margins of discretion for the government to do whatever they like, which quite a number of states, particularly the common law countries, had taken for a long time. The committee, since the Vienna World Conference of 1993, has made it quite clear that in each of the covenant rights, of both covenants, there are issues, the core content of these rights can be framed as claim rights and that are immediately applicable, so that when you ratify, it's not just a carte blanche for the thing. And when I went to Japan and the judges said, well, no, that's not for us to decide. This is just an international obligation which the government or the parliament could do. We will not interfere. And then I said, but the obligation, having ratified the government, is on the state as a whole. And the state is not just the government, it's also the judges. So you can if you want to. So they need to be told. Sorry, that was just a little comment. But it's all in general comment number 3, and I look here to my colleagues who worked on it.
No.
Yes?
5 minutes?
We have another 5 minutes, but I think we still have one outstanding question from you, and then on the common core document. So what I had planned originally, that we should begin a discussion on 2, and 3, and for the other group on Article 2, 3, and 26, we leave that for tomorrow. So, but we take your question now.
Following in on what you, the chair, have said about the need to tell judges that they have the authority to decide on the claims pertaining to rights claimed under the covenants, judges also say, but present me with a good argument for this. And therefore, it's not only judges that have to be told, but the lawyers who are taking up the litigation. The client, the litigant herself or himself, may not definitely have the knowledge. And if lawyers taking up the case do not bring this argument to the courts, the judges are not going to, on their own, rule in that manner. Although even in bringing the argument to the court, the judge may be, as somebody said, ignorant and timorous, but nevertheless, there is value in getting lawyers also educated when they present their cases. Yeah.
Thank you very much for your question, and perhaps a final comment on this cluster of a common core document issues. Is there anything that you expected us to ask you that we didn't ask? But we only have 5 minutes. I see from your reaction that that is not the case. So we did cover quite a lot of important issues. Well, let me take this chance, unless somebody very urgently on the bench here would wish to raise another issue. Then I would just like to
want to have a question to us.
Yes, maybe you have a question to us. Very good, very good, yes. Do you? But of course I can, yeah? No, okay, but of course there are 2 more days, and if you do have questions, don't hesitate to. This is a dialogue, and it helps us for the concluding observation, and it helps you. Well, first of all, let me thank you all for coming today. This has been a very, very rich dialogue from my perspective. I'm sure my colleagues see it the same way. I wish the quality of the dialogue had been like this in the many, many years that I served on a committee. Only rarely has it been as intensive and as good as here today. You have really prepared, and your on-the-spot answers were really extremely helpful for the committees. And with that, I close the meeting only to say that tomorrow morning we will meet again with the NGOs for 1 hour on the first cluster. And then we will begin the dialogue in the afternoon with the government.
No, in the morning.
Oh, in the morning. Sorry, I don't have the list.
In the morning we separate.
Yes.
It will be the separate clusters. So one committee on economic, social, and cultural rights will be, I think, in 202, if I'm correct,
Yeah.
and the committee on civil and political rights will stay here in this very room. So we look forward very much to meeting you again tomorrow morning at 10 o'clock.
Okay, yes. Well, with that, have a nice evening, and once more, thank you for all your valuable contributions, and we really appreciate how seriously you take human rights issues. I mean, all the material I have there, it just bears witness to that, but paper is patient, but in the discussions, the way you answered the questions is very helpful for us and will facilitate our in prioritizing issues where the committee, both committees feel that something needs to be done. Okay.
Thank you.
So we tomorrow morning we meet at 9. This evening we meet at 5:15.
No, in quarter of an hour. No?
In a quarter of an hour.
Here.
Yes, here. Yes, with the NGO. But if anybody from the government wishes to listen in. Thank you.
Thank you.
The meeting is adjourned.
Thank you.